Well, good afternoon, everybody. Good afternoon, folks. And thank you so much for staying with us for this last panel of the day. This program, which has been hosted by the Brennan Center and the National Constitution Center, it has offered such thoughtful and insightful conversation from leading scholars, and our hope is that we're going to continue that one with this third panel. You will bear with us. The breadth of this is, the scope of this panel is a little wider. We follow the last two panels to cover everything basically up until today. And so we'll try to get to it all. Without further ado, I do want to quickly introduce my panelists here in this conversation. So to my right is Amanda Shanor, who is an assistant professor of legal studies and business ethics at the University of Pennsylvania. To her right is Ilya Somin, who is a professor of law at the Antonin Scalia School of Law at George Mason University. And then finally, last but not least, is Alan Trammell, who is a associate professor of law at Washington and Lee University. And so as I said, this panel is going to cover a bit of a longer stretch of time, more or less, where we left off from the convention today. But I'm going to jump into a period that has been mentioned a number of times because it has been so transformative for our country, and that's the Reconstruction period. So we have the Reconstruction Congress, which adopted amendments that the states subsequently ratified to expand the realm of constitutional guarantees. So we have these amendments, the 13th Amendment, the 14th Amendment, the 15th Amendment, critically abolishing slavery, guaranteeing due process, and really non-discrimination by the government in all realms, but specifically voting in the case of the 15th Amendment. Essentially, they sought to make all men equal. And I want to highlight the word men, because at that time, we are still in a period where we are talking about men, but equal in terms of their rights and responsibilities under the law. And in doing this, the Reconstruction Amendments also expanded federal government authority, while at the same time constraining state power to prevent these states from debasing the new constitutional provisions. So that long winding up leads to my first question, which is basically, I would love for some of you, all of you, to explain more concretely how the Reconstruction Amendments altered U.S. federalism, this relationship between the federal and state governments and the constitutional order more generally. Grab bag.
Okay, so that's a question we could probably talk all day about. I'll just mention two things. One is obviously the original Constitution included very few constraints on state government's abilities to violate individual rights. There was the Contracts Clause, there was a few other things, but for the most part, states could restrict individual liberty as much as they wanted to, at least insofar as the federal Constitution was concerned. The Reconstruction Amendments obviously add a whole panoply of constraints on state government's ability to restrict liberty and property rights in various ways, both in the 14th and 13th Amendments and 15th themselves, but also in the incorporation of the Bill of Rights against state governments, which was a major transformation. Before that, the general assumption held by most people, including the Supreme Court, was that the Bill of Rights only constrained the federal government. This is often seen as a big expansion of federal power, and there's definitely was some expansion of federal power under the Reconstruction Amendments, but it's worth noting that the federal government also gets constrained in some ways. Most obviously, some of the most controversial actions of the federal government before the Civil War were those taken in defense of slavery, like the Fugitive Slave Acts, for example, and some others as well. That was taken off the board. The Citizenship Clause extended birthright citizenship to all people born in the United States, now the subject of litigation once again. That constrained the federal government's power over citizenship, which had been significant before the Civil War. So there are both constraints on the federal government and constraints on the state governments, the ones on the state governments being a big break from the previous relative lack of constraint, but it's worth noting most of that constraint on the state governments is not for the purpose of giving more power to Congress or to the president, but for the purpose of protecting individual rights and liberties for the people within those states.
Well, so I just want to follow up on one thing that Ilya said, which is that, and also, it's such a pleasure to be here. Thank you very much in this beautiful space. So one of the important points here that Ilya highlights is not just a change in the relationship between the state and federal governments, but what happened with the Reconstruction Amendments is really the necessary predicate to the rights culture that we have today in the United States. So before the Reconstruction Amendments, the Bill of Rights only applied against the federal government. So you didn't have a First Amendment right against a state government. You didn't have freedom of religion against your state government unless you had that under your state constitution, but not under the federal constitution. And so what happened after the Reconstruction Amendments, in addition to what was important about them in particular, was that the Supreme Court over a period of time incorporated the Bill of Rights, which means applied them through the 14th Amendment against the states. And without that, we wouldn't have those Bill of Rights, all of the sort of like panoply of individual rights that we think that we have now, we get actually by way of the 14th Amendment in significant part. And so what happened with the Reconstruction Amendments was not just this important transformation about who the Constitution includes within its polity, right? Who is within the we the people, but also this fundamental shift of the relationship between individuals and governments at all levels and in terms of what their individual rights are.
And I'll just add, by putting those together, Ilya talked about the structural elements, what changed structurally as a result of the Reconstruction Amendments. Amanda's talking about the rights culture that gave rise, or that was birthed by the Reconstruction period. And I simply want to zoom out for a moment and note that a lot of this remains very contested history. Some of the historians of the Reconstruction period will say that it's one of the most misunderstood periods in our history. Precisely because of that, there are these ongoing fights about constitutional interpretation, exactly what was promised by these amendments. And it's interesting to go back and to look at the Republicans who were elected in 1864, who were part of that Reconstruction Congress. We often talk about the Republicans and the way that they pushed back against Andrew Johnson, but in fact, the Republicans of that era were not monolithic, the same way that Democrats and Republicans today are not monolithic in terms of the way that they view the Constitution. And so a lot of the debates that we are having today about the nature of federalism, to what extent was federalism transformed by the Reconstruction Amendment? Were these little tweaks? Was this a massive inversion? All of those were live debates. The radical Republicans and the moderate Republicans did not necessarily share a common vision of that. And they debated what the ultimate goals of Reconstruction should be, whether that was going to prioritize bringing Southern states back into the Union, whether it was going to be trying to consolidate the gains of the Civil War, especially with respect to racial equality, and exactly what we mean by equality. It's worth noting, by the way, and we're probably going to get into this a little bit, but there are analogs in Section 1 of the 14th Amendment in the original Constitution. There's a due process clause in the Fifth Amendment that operates against the federal government. So too, there's a privileges or immunities clause. Well, privileges and immunities in the original Constitution, the conjunction doesn't make a difference. It's grammatical. So the question then is, what about that new clause, the Equal Protection Clause? That becomes the font of so much debate that we have to this day. What exactly is that promise of equality? Is it social equality? Is it political equality? What exactly does that entail? And so those ongoing debates very much remain live, and I guess where I want to leave it for the time being is to note that the framers of these Reconstruction Amendments did not think that they were resolving these questions for time immemorial.
So I want to follow up there. You spoke about this contentious debate over the meaning of these new provisions, Alan. Today, it seems, at least from my perspective, that the Reconstruction Amendments often get short shrift. at least relative to the original Constitution. Now, there's a lot of litigation over the 14th Amendment, as you said, but it's not always consistent, and it doesn't always seem like that interpretation goes far enough to capture the conditions of today. Now, perhaps that's just my perspective as a constitutional law professor, but I'd love to know what's the cause of this? What's the reason why some, like me, might see that the Reconstruction Amendments are not, they're playing second fiddle to the rest of the Constitution?
I'm not sure that I accept the premise of the question, in that I've heard it said for many years now, precisely what you just said now, that we're giving short shrift to Reconstruction Amendments, but it's a little like saying if enough people say that something is underrated, then after a while it's not underrated anymore, because most people realize at least something closer to its true importance. So then you can still argue that there are certain aspects of the Reconstruction Amendments that don't get as much attention as they should, but I think if you look at litigation in courts, the 14th Amendment may be the single most litigated amendment. If you look at scholarship in the law schools, once again, probably there's at least as much 14th Amendment scholarship as scholarship of almost any other provision of the Constitution, at least that I can think of. So I think there is a lot of attention. You could say there should be still more, and you could say maybe some of that attention isn't asking the right questions or is reaching the wrong answers, and I think all of that might well be true. But I do think there is a growing understanding both in the courts and in the legal academy, possibly even in popular culture, with the growth of attention to racial issues and obviously the Civil War and its aftermath, that there's a sense that the Reconstruction Amendments, they're at least close in significance to the original Constitution, if not actually on a plane of equality. So I think it would have been legitimate to say 10, 20, 30 years ago, we're not paying enough attention to Reconstruction Amendments, maybe, but that attention has grown, at least since the Civil Rights Movement, and it continues to grow now, I think.
So I completely disagree with Ilya. I wish I could agree with you, but I think there are two levels at which the Reconstruction Amendments have, both historically and sort of in our contemporary moment, have been given short thrift. And one of them is doctrinal, and that's because immediately after the adoption of the Reconstruction Amendments, the Supreme Court, as I teach my students, just punched them in the face, right? Completely from their birth, eviscerated them in really important ways, okay? And probably everyone knows about Plessy v. Ferguson, for example, which interpreted equal protection to permit separate but equal, okay? But in addition to that, we had the slaughterhouse cases, and so under the 14th Amendment, you have three sort of substantive clauses in addition to birthright citizenship. You have privileges and immunities, equal protection, and due process. Most people haven't really heard or thought about privileges and immunities, and why is that? Because in the slaughterhouse cases, very early after the passage of the Reconstruction Amendments, the court just essentially read privileges and immunities, which is where the framers of the Reconstruction Amendments really thought that the big bucket of new important rights and protections were going to be, and essentially read it out of the Constitution such that it's not really important within our constitutional discourse today. But that's where the Reconstruction framers thought you were going to get the most important rights, right? Now we have litigation under due process and equal protection, but we lost that because of slaughterhouse. And then in addition, in the civil rights cases, the court read the 13th Amendment to be very, very narrow, just about the end of chattel slavery, and potentially a little bit more, including badges and incidents of slavery, but in a very narrow sense. And they decided that the 14th Amendment only applies against state actors, against governments, and not against private actors. Those doctrinal decisions really incredibly narrowed the promise of the Reconstruction Amendments in ways that had very long shadows into the present. And then in addition, in part because of the backlash against Reconstruction, and then later against Brown v. Board of Education, we have a constitutional discourse particularly from originalism, that is focused predominantly on the original Constitution, what the original framers thought, and that is like the core sort of gravamen of what the Constitution means, as opposed to the far more audacious ideas of a radical equality that many of the framers of the Reconstruction Amendments adopted. And which is why I hope that actually Ilya will become right, that those are some of the things that are more central to our discourse, as opposed to sort of like just the original Constitution.
I do want to give Ilya props on one aspect of this, which is that law professors really are thinking and writing about the Reconstruction Amendments a lot more. I also think that Amanda's right, that there's a path dependency. That's the way that I talk about it with my students. There's a path dependency that comes with the civil rights cases, with the slaughterhouse cases, as the big, bold vision that the radical Republicans had for the Reconstruction Amendments winds up getting shrunken down to this almost unrecognizable shadow of itself. And so we see that the Equal Protection Clause, this brand new clause, is suddenly having to do a whole lot of the heavy lifting that the Privileges or Immunities Clause was supposed to do. We see that the Due Process Clause is now doing this backflip of having a substantive element to it, which Justice Thomas calls a contradiction in terms. And in some ways, he's very right about that. But simply pointing to those particular problems, those anomalies, is to ignore the history that Amanda was talking about. The fact that there were certain periods immediately after Reconstruction when we saw an enormous pushback from the Supreme Court, and we're going to talk, I think, about the period of Jim Crow, when you essentially see the Supreme Court giving Southern states carte blanche to largely recreate the badges and incidents of slavery that supposedly had been abolished in the 13th Amendment. One final note is that there was a whole lot of debate in 1866 and 1867 about the extent to which the 13th Amendment already handled a whole lot of these big goals of Reconstruction. Whether the abolition of slavery meant also the eradication of differences in race when it comes to civil rights, social rights, political rights. That, again, was seriously debated. That necessitated, in some ways, the 14th Amendment to try to resolve whether some of the Reconstruction statutes indeed could pass muster. So, again, these debates remain live, and I think that because of this path dependency, that's why law professors essentially are guaranteed full employment, at least the common law professors.
So certainly, recent history is a full employment act for constitutional law professors. I think Amanda's right that it is the case that in the Slaughterhouse case, just 5 years after the 14th Amendment, the Privileged Immunities Clause is largely neutered, and it has not, for the most part, been revived to this day, though some Supreme Court justices, including Clarence Thomas, actually have advocated for reviving it, but so far they don't have 5 votes on the court, nor does the Privileged Immunities Clause have a lot of resonance in popular culture either. That said, I think there has been tremendous attention and also tremendous use for the other 2 big clauses of the 14th Amendment, the equal protection and due process. And I think due process actually is not actually true to say it was originally meant only to be a procedural protection, because due process of law was actually understood in a different way in the 19th century by most people than the way we today might understand those words. They did not think of it as purely procedural, but certainly with privileged immunities, that work that clause was supposed to do, it never really has done, because by a close 5-4 decision within 5 years after the amendment was ratified, the Supreme Court ruled that the Privileged Immunities Clause has only this narrow significance. I think that was a mistake. I'm not convinced that the civil rights cases was a mistake. That's something we could perhaps have a discussion about. Obviously, Plessy versus Ferguson was wrong, but that was part of a broader historical movement to sort of retrenchment after Reconstruction. But I think the Reconstruction amendments, particularly the 14th, continue to be major focuses of debate and discussion today, and they're a big part of the workload of the Supreme Court and other lower federal courts, and therefore I'm not convinced they're generally underrated, even though there are certainly some things that we should be using them to do that we haven't sufficiently use them for, and there are some parts of them that I think the Supreme Court and other political entities continue to misinterpret.
I would be remiss not to just say that a lot of my scholarship has to do with the Reconstruction. So yes, scholars do love the Reconstruction period, and it does give us job security. And I would also be remiss not to pick up on 2 points. One is Ilya's point, which is that, you know, there is increasing amounts of scholarship and opinions that use the 14th Amendment. That said, where he spoke about the incorporation doctrine, that's also doing a bunch of it, right? So they're not technically writing about the 14th Amendment, but these other parts of the Constitution that the 14th Amendment incorporates so as to apply to the states. And then, just as Alan was bringing up, the debate about the privileges and immunities, and it's what exactly does that consist of? We had some understanding what those were initially, but what exactly that would mean now, and if that genie could even get back in the bottle, as Justice Thomas tries to argue for so far unsuccessfully. But I do want to raise the point, Amanda, I believe you mentioned originalism, so let's talk originalism. Originalism, for most of you out here, most of you might have some idea, but it's at present pretty much, I'd say, the dominant theory at the Supreme Court in terms of constitutional interpretation. And what it says is basically the meaning of the Constitution was discoverable at the time of the founding, this public meaning of the Constitution. And so the Constitution takes hold at the minute of adoption, at ratification, and that's authoritative. And we can know what it means today and how that applies to current situations today by investigating that. And so if we ask the public then, we can figure out the meaning of questions today. I'd love to know more about the historical evidence for this methodology, this approach to interpretation. Was that something that the framers wanted? Do we have evidence from the convention, the ratification debates, that we are supposed to be interpreting the Constitution in this way that is, you know, reasonably static, back what they thought at the time of ratification?
Can we enlist a guest panelist?
I know. Jonathan, do you want to respond? So we didn't have, so the answer, I think, as Jonathan Knapp's fabulous scholarship will tell you, is that quite the reverse. The framers were not at all originalists, and had I had a little thing to write on, I would have asked for that question because I wanted him to answer it before our panel. But this tells you a few different things, and I'll tell you. So one of the things I study is the way in which social intellectual movements change the sort of popular meaning and understanding of the Constitution. And actually, where originalism as we think of it today came from is the 1980s. It came from the Reagan Revolution, and specifically from the absolutely brilliant work of Attorney General Edwin Meese, who was Attorney General during the second of Reagan's terms. Okay, and in that context, he wrote, and his Department of Justice wrote and rolled out the idea and really popularized, didn't originate, but popularized the idea of originalism as we know it now, and particularly as led to a certain set of policy and ideological understandings that were popular and that he believed, I think that administration really believed at the time, but that included significantly the backlash to Brown and the idea that affirmative action was unconstitutional. And so the idea of originalism that we have today is certainly not the one, not the mode of the framers. So for example, Jefferson thought that we needed a constitution every 20 years, for every generation. I guess generations maybe were shorter, okay? Because we had a changing constitutional project, and in fact, that's what we've seen. And one of the things I'll say about Meese, that is one of the reasons I think he's really, even if I substantively disagree with him, was sort of like incredibly thoughtful, is he understood how deeply our Constitution is a living, changing document, so much so that he knew how to maybe seed a set of ideas that would make a whole lot of people think, no, it's not. In fact, it's something that is set, and that is the only thing that the Constitution can be, and we must obey that history, and that leads us to a limited set of understandings of what the Constitution is, when in fact there are many more, and history, including Reconstruction history, might teach us very different lessons about what the Constitution can and should mean.
So once again, I would challenge the question a little bit on two levels. One is actually there is a good deal of evidence of people using what we would today call originalist methodology in the 18th and 19th century. James Madison said at one point, to be sure, years after the Constitution was ratified, that it should be interpreted as understood in the ratifying conventions and by the people. If you look at a lot of 18th and 19th century litigation, you see many examples of judges on different sides of issues making what we would today call originalist arguments. That's true, for instance, of both the majority and the dissent in the Dred Scott case, that you see a lot of arguments about how this was understood in 1788 and 1789. You know, Taney makes one set of arguments, Justice Curtis in dissent makes another, but both of them are making what we would today consider originalist points. The second point that I would make, perhaps more substantial, is that the justification of originalism, I would argue, does not in fact depend on whether the framers were originalists or whether the framers of Reconstruction amendments were originalists or whether any particular person in the past was an originalist or not. Rather, I think the best arguments for originalism are process and consequence based. One set of arguments developed by John McGinnis and Michael Rappaport is the idea that the original meaning is better than living constitutionalism because the original meaning went through a supermajoritarian ratification process and is better for that reason. It's more likely to create beneficial rules when the rules have to go through that process. Another possibility is that there might be other reasons why the original meaning generally creates better consequences than letting judges make changes through living constitutionalism or just deferring to whatever the political branches want. So I think the best justifications for originalism are ones that do not in fact depend on whether James Madison or George Washington or John Adams or other, or for that matter, the framers of the Reconstruction amendments themselves believed in originalism or not. And obviously also there are many originalist arguments and theories of originalism that long predate Ed Meese and the Reagan era. Obviously, there are different versions of originalism, and Ed Meese and his cohorts had a particular version that they were trying to promote, but the basic idea of interpretation in accordance to how the Constitution was understood at the time of ratification, that long predates Ed Meese by probably almost 200 years.
Alan, can I ask you a follow-up question? Perhaps maybe you can talk about a point, clarify maybe the distinctions between drawing on history and originalism as a methodology itself.
That was the deep breath that I was taking.
Yeah,
I was about to say that.
People here know we don't really put historians on the court. We put lawyers, and
right.
Yet we are using these deeply historically inflected arguments to make constitutional moves. And so I'd love to know that distinction.
Sure. This is something that I probably say until I'm blue in the face in my classes, that there is a distinction between history and originalism. History is an effort as best we can to understand what happened in the past, the motivations of the various historical actors. What we do with that is a political normative choice, and it is very much a choice. I would certainly agree that what might pass as at least a pseudo-originalist move can be seen over decades, perhaps even centuries, but the originalist project, in its current form, I think Amanda is right, really is something that traces back to the very recent past. And so how we understand that distinction between history, being attentive to history, being curious about it, drawing on history, is very, very different than saying that that is our destiny. And so it is good and right that judges will consult history, that they will consult historical traditions, experience, but also that they will take account of the consequences of their rulings, that they will look at the actual text and the extent to which there might be tension between text and that originalist gloss, if you will. So, for instance, if you look at a lot of European countries, they very much will consider drafting history when interpreting certain constitutional provisions. But they go beyond that. They use other tools. They're much more eclectic in terms of the tools that they use. Now, that's not to say, well, if they're doing it, they're sophisticated, and therefore we should try to do the same thing. But it is to say that maybe we should be a little bit more reflective about our constitutional methodologies and to recognize that there is at least a debate there as well. One of the things that drives me crazy is when certain people, and I am casting no aspersions on anyone in this room, but when certain people will act as though somebody who is not an originalist doesn't just disagree with them, isn't just advocating a different methodology, but that those people are not doing law. That is what really drives me crazy, because originalism is not law. It is a methodological choice that we make. And we can make all sorts of methodological choices that are informed by history, but ones that don't require us to slavishly follow that history.
I'm just going to jump in to take a moment to remind the audience to please raise your hand with your question cards if you have them. People will be around to collect them. We will get to that moment, that portion of the discussion shortly.
Well, so I'll just follow up a tiny bit about how do we think about not just originalism, but this really broad and very important question about what the role of history and arguments from history should be within constitutional law. Because if you think sort of like more broadly about history, we can learn a ton of things from history. We can learn about good things that we might emulate. We can learn about bad things that we should seek to avoid. We find heroes, we find villains, right? And originalism just looks at a certain part of history and says that's the thing that determines what the Constitution means, whereas in fact we can look at a whole broader set of history, including the voices that were locked out from, for example, the moments of the founding or even in Reconstruction, and say that we will listen to more folks, like we'll listen to Frederick Douglass, right, or Louis Stanton, or other people who might actually have been important contributors to the constitutional project. And if we think about history in that much more broad way, history actually can be a source of learning and guidance of what we maybe want to do, but it's also really publicly important, right? So if you think about history, what history does, it's about the stories that we tell about what the Constitution means and what our history means. And that's really important, but it's also important because of the histories and the stories that we leave out. Because what history does is it encodes what is normative, what should happen, what is normal, what should we expect, including from our institutions and from our Constitution. And in that way, I do think it's very important that we try to open up the world of history, including to Reconstruction and beyond, so that we can have more voices in what is the sort of like larger multiracial democratic process.
Could I just piggyback a little bit on that?
Yeah, go for it.
Before you jump in, Ilya, to note one example, because we have been talking about the Reconstruction amendments. The history of Reconstruction has been reinterpreted many, many times over the last several decades. And part of that is this project of inclusion. One of the things that many people in this room probably learned is that Reconstruction was an abject failure. Well, that is a particular thesis associated with the Dunning School of Reconstruction, and that's been interrogated quite vociferously by including more voices, including the voices of the freedmen in particular. And understanding that history then sheds light on constitutional praxis, and as I say, what we then do with that becomes a political choice down the road.
Yeah, so it's interesting you made that point about the idea that Reconstruction was an abject failure. It's definitely true that idea originated with the Dunning School and the racists of that era. Ironically, in more recent years, have been taken up by what you might call the opposite side of the political spectrum, the critical race theory people and others who say Reconstruction failed because racism is inherently embedded in American history and institutions, and therefore we need to reject this entire sort of project of liberalism and instead have something else. So there's a kind of convergence of the Dunning School and some people on the far left in saying the Reconstruction was a failure, when I think in reality what happened is it didn't succeed nearly as much as it should have and could have, but it was still a big improvement compared to what came before, which was, of course, was slavery. But in terms of thinking about originalism in history, I agree originalism in sort of historical research is not the same thing, because originalism asks a particular set of questions which is narrower and different from those that historians might ask in other contexts. So you might say, why, ask those questions that originalists say we should ask, as opposed to just look at the entire sweep of American history and include all the possible voices. One possible answer is that the original meaning is what went through the supermajoritarian process of lawmaking, whereas what people thought at other times, while it might be right or wrong, that's not what went through it. But the other is that I think if you look at the two big moments of constitutional transformation in American history, where the text of the Constitution was created and changed, the original Constitution, and then the Reconstruction era with the 13, 14, and 15 amendments, you see periods when the ideals that people were trying to promote were actually really good ones, those of Enlightenment liberalism, liberty, and equality. And if we're going to choose sort of what periods of history we want to build constitutional interpretation on, it should be ones that promoted those high and beneficial ideals, even if though they certainly didn't fully succeed in instantiating them. If you want to be more inclusive and include the long sweep of history, then you're going to include, it's easy to say you want to include the voices of women and minorities, but if you're going to include all periods of history and all evidence from all eras, then you're going to get the redeemers, the people who wanted to reverse Reconstruction. You're going to get all sorts of horrible and unjust political movements from various periods. I would say one reason why I'm willing to be an originalist about the US Constitution is because the lion's share of the original meaning of our most important constitutional provisions was created by these two generally beneficial and liberal-minded movements, the original framers, and then even more so the Reconstruction framers. If we had a different history, then I think that would be an argument against originalism, at least from my point of view, where I think originalism, like any constitutional theory, has to be justified by its results rather than because people who lived 150 or 200 years ago, we have some sort of inherent obligation to obey their will, which I don't believe that we do.
I'm going to move away from originalism for a second.
Forever?
No comment. During the Articles of Confederation, the debates over them, James Madison itemized 12 defects regarding the Articles, these vices of the political system that existed prior to the Constitution. And so this question is going to pick up on a discussion that Congressman Raskin mentioned in his keynote on a comment or a question made by Professor Edebar. I want to talk about the presidency, right? We had this listing of defects, most of which had to do with state encroachments on each other, not paying these requisitions, not demonstrating that necessary comity for a union. And so notably absent from these defects was anything about the executive. Now, we know the presidency today is not the presidency of the framers. The presidency itself wasn't the primary focus of the convention. Much of the discussion came later after they decided how they were going to vote for the presidency. And we had this sort of backdrop, this ominous sort of vision or specter of King George, right? And at the same time, we had this huge stature of George Washington, who was going to be the president in front of the convention. And so we have this discussion of this office, sort of limited, slighted, and now we have this executive today, which has grown over the period of centuries to become a huge position. I'd love to know how that, I guess I said I was going to move away from originalism, but does today's presidency accord with the originalist theory of constitutional interpretation, how originalists see the Constitution?
I think pretty obviously not. As you said, the power of the presidency has vastly expanded since the 18th century, or even since 100 or 150 years ago. Some of that has to do with the president grabbing power compared to other branches of government, which he's often well positioned to do because it's easier to make decisive action when you're one person administrative hierarchy as opposed to when you're 535 people in Congress, but some of it has to do with the growth of the federal government generally, also often in ways not in accordance with the original meaning, which has made it difficult to prevent the growth of executive power in an era when the federal government regulates or taxes or both almost every aspect of our lives. It's hard for Congress not to delegate enormous amounts of authority to the executive, which then further grow this office and further create serious problems and dangers. There obviously is an argument that all of that or most of it is justified because of the needs of the modern world. I largely disagree with that. I think actually having a more complex world means that the case against governing it from one central government actually is stronger in some ways than a supposedly simpler world. But whatever you think about, whether the development is a good one, it certainly is a development that has gone beyond the original meaning. I will make one point, though, about King George, and I'll stop, that we today think of the revolution as a revolt against the tyranny of King George III, and of course, the Declaration of Independence singles out the king and criticizes him. But in reality, British government in the 18th century was already one where Parliament had a lot of power, and the guy who actually implemented and conceived of many of the policies that led to the American Revolution was not King George III, but Lord North, the Prime Minister, who's usually not thought much about today, but he was at least as much responsible as George III, and the framers, of course, well knew that, and that may be one reason why they were at least as much afraid of legislative power as of the power of a separate executive like the king, because they remembered Lord North and his depredations, even if today most of us don't.
I don't have a ton to add. I mean, I think that Ilya's right, that our current imperial presidency in no way accords with the presidency that was envisioned in the late 18th century. The one thing that I would add to that in terms of updating our understanding, I guess I would push back a little bit on the idea that a stronger presidency is not needed in the modern era. I actually do think that a stronger president is needed in certain arenas. You can think about waging war. Our current Congress, all due respect to Congressman Raskin, is not capable of waging a war together. So this might be an area where you would say, okay, it's important that the president have the ability to act with energy and act with dispatch. The flip side of that, though, is that one of the things that political scientists look to most frequently when thinking about democracies in decline is a concentration of executive power. And that is something that we see across a number of countries. It has been a warning sign at various points throughout our history when there has been too much concentration of power in the executive. And it gets especially dangerous when you look at some of the other threats to democracy that are present now, but that's not the question on the table.
I want to add just a little bit to that, is that, so certainly it is the case that we have a far stronger executive than anybody at the founding possibly could have envisioned. Elena Kagan, when she was an academic prior to becoming a justice, wrote a really important article showing how that's been the case for over many different presidencies of all different political stripes. I think that the moment we're in terms of the claims to executive power, though, really stand pretty sharply more aggressive or robust than in earlier eras, except for maybe in the kind of like 9/11 period. But even with regard to that, those claims were for a much more narrow set of things, as opposed to now sort of like more global invocations of Article 2 as giving not just executive power to rule by fiat through executive orders and memoranda, but also to say that that is exclusive and preclusive authority of the executive, meaning that there is no judicial review. So the executive can, for example, ship people off to a foreign country, okay, to a really brutal prison without due process, and the argument is, well, that is within my sole authority, and it's a separation of powers problem. It's an overreach of the courts to say that the courts should have any type of review of executive action. And I think that that is quite more aggressive. I'm interested to hear what you all think. Quite more aggressive than we've seen with any modern president.
I think in some ways that's...
I just want to say we have 5 minutes until the Q&A, so please your cards up if you have them.
It is very aggressive, and I condemn it. I've even written about why his attempt to use the Alien Enemies Act in this way is wrong on many, many levels. Google my name and Alien Enemies Act if you're interested in it. That said, FDR and some past presidents at times made similar awful claims during previous crises or even sometimes during invented crises. So the abuses of this administration, while very real and very serious, do have some historical precedents. I think the answer is not to say, well, that means everything is well and good. It's to say it was wrong then and it was wrong now too, but it didn't just purely come out of thin air.
Yeah, undoubtedly we've had this explosive growth in the presidency, which has seen real spikes at certain points. FDR is clearly one of them. Lincoln was one of them. You know, Reagan was one of them. We've seen these periods where the presidency has just expanded in these ways. And then we would also just be remiss not to remember the immunity decision. So Amanda spoke about the preclusive and exclusive presidential powers and what that has meant for politics today. But this is all occurring against the backdrop of immunity. So not only can they not be questioned, but no one can be, or at least one person cannot be prosecuted for, you know, going forward and acting in those ways.
I think that was a bad decision, and I've criticized it. That said, in the entire history of the United States, not once have we actually criminally prosecuted and successfully convicted a president for things that he did while in office, even though, frankly, there are times where we should have done it. Like FDR, I think, should have gone to prison for the Japanese internment, and there's other examples like that. And the immunity decision itself, it is, to put it mildly, not a model of clarity. It does not simply say the president gets immunity for everything he does while in office. Rather, it says for core inherent powers, he has total immunity. For other official acts, maybe he has immunity and maybe he doesn't. Maybe we'll tell you in a future decision how much immunity he has in those situations. So that, I think, was a bad decision. It's vague, it has problems, but it should not be said that it gives absolute immunity for everything a president does in office, because it doesn't say that. And to suggest that, I'm not that you necessarily suggested it, but to suggest that it does merely just reinforces certain hubris that currently exist in the White House or may exist in the future. Much of the import of that decision actually remains perhaps for future decisions to interpret and decide.
We'll be seeing what my law school students think about that after I grade their exams.
Slight historical correction, Ulysses Grant got a speeding ticket for riding his horse too fast.
Duly noted, I should have remembered about that, and I apologize for that omission. Though, as I understand it, that didn't actually go to court. Like
that's true.
The law enforcement officer gave him the ticket, and to his credit, he did not say, "I'm the president, so I get to do what I want." He said, "Okay, fine, I'll pay it."
Yeah.
Okay. So I have a few audience questions. I'm just going to chime in with one that stands out to me. Is it truly objective, balls and strikes, that is being done at the Supreme Court? Is balls and strikes actually this mode of constitutional interpretation? And if it's not even being done, is it possible?
Just before this panel, Alan and I were talking about how we're both baseball fans. So I do think balls and strikes is a reasonable way to model it. It models the idea that judges are supposed to be neutral and are supposed to not just impose their personal preferences. At the same time, if you are a baseball fan, you know that what's a ball and what's a strike is sometimes ambiguous. You also know, and there's a lot of evidence for this, that different umpires have different strike zones. Some might be a bit higher, a bit lower than others. So while I think this is a useful metaphor and a useful ideal to strive for, when you think about it a little bit more carefully, it also reveals that things are not always clear-cut, and that different umpires, or in this case, different judges operating in good faith, might still come to different conclusions or even use somewhat different methodologies to reach those conclusions. So the balls and strikes metaphor, properly understood, does not mean that there is a unique and easily discoverable set of correct answers, that will just fly off the page of the Constitution or of statutory law. Sometimes that's true, but other times, as with some of these relatively vague phrases like privileges or immunities, necessary and proper and so on. There's going to be ambiguities, and there's going to be a lot of difficulty in figuring out what the correct resolution is.
So our Constitution is incredibly short and has very open textured language like equality and liberty. And it's also, as an earlier panel discussed, incredibly hard, at least in modern circumstances, to amend. That puts a lot of sort of hydraulic pressure on courts to do interpretation as incredibly huge changes in society and economy, et cetera, occur. And because of our political moment, we have a lot of things have pressed upon this particular court, and a lot of sort of serendipitous, I guess, I don't know, like contingent facts of life that have meant that we have a court that is really sort of like minority rule within, we have a court that's very not representative of the American public. And part of that just has to do with when justices died, and it also has to do with the whole Merrick Garland situation, okay? And that has meant that we have a very specific court that is doing different things than I think a lot of folks necessarily would choose themselves. One of the things that means, I think, is that we do need court reform, particularly in terms of having term limits for justices, so that every president or every term gets to appoint a president, a justice, which means that we will have a more representative and a less sort of like politically fraught sort of like push towards grabbing seats on the court with the goal of controlling what constitutional meaning is in important ways.
Let me just add two things to this part of the conversation. One is that there can be very, very different methodologies in terms of how a judge approaches a statutory interpretation question, precisely because statutes are passed by a majority of Congress. They can be relatively easily repealed, as opposed to constitutional interpretation. Those are very, very different enterprises. And I think that you can be a textualist when it comes to statutory interpretation, but then recognize that a constitution is a fundamentally different document. It's a framework document. I think that Professor Roosevelt was alluding to at least that particular conception of the Constitution. And to recognize as well that there is not going to be a single right answer to the meaning of these open textured provisions like equal protection, due process, and the like. There will be certain provisions that are seemingly ironclad. For instance, that the president has to be at least 35 years old. Some of us also think that the 22nd Amendment is ironclad, that the president only gets 2 terms, but apparently that's up for debate now as well. And so I would simply note that balls and strikes, Ilya's right, is a useful metaphor. The one other thing that I would say is that when we think about balls and strikes, it implies that there is a methodology. And that doesn't necessarily mean a single methodology that people have to adhere to. We talked about originalism earlier. In fact, throughout most of United States history, there has been a pretty eclectic approach to constitutional interpretation, drawing on all sorts of different sources in trying to understand how we cash out the Constitution today. And again, to come back to something I was saying earlier, I think that it behooves us not to cast aspersions on people who disagree with us methodologically to suggest that somehow they are not doing law if they don't share that methodology.
Yeah, so I want to sort of combine a couple questions here, but it picks up on Amanda's point about amendments. John and I wrote about amendments in our book, The People's Constitution. The Brennan Center has taken a position about Supreme Court reforms. I've had many others. And I guess I want to sort of combine some questions and bring it back to the Articles of Confederation. So the Articles of Confederation are OG, or our OC, as you will, the original Constitution. Turns out that the Articles were just this first draft, and it raises the question, is this just a second draft? You know, when we were writing this book, I wrote a piece for The Atlantic called America Needs a Third Reconstruction. Does America need a third constitution?
I say yes. And in fact, that's one of the projects that I'm working on right now. I alluded earlier to various indicia of democracies in decline. a number of political scientists recently have been writing about this. In addition to concentration of power in the executive, they will point to rising income inequality. They will point to vociferous debates about who is included within a polity. And they will also, fourth and finally, what did I say? Concentration in the executive, rising income inequality. Oh shoot, I'm forgetting the fourth one.
The Department of Education?
Wow, touche. In any event, we have all four right now going on in our country for the very first time. So I know that people will say we have weathered significant storms in the past, we have survived a civil war, but we have never faced quite the same challenges that we do at this moment in time. And I don't know exactly what that looks like. Article 5 probably is not, at least if you subscribe to a notion of popular sovereignty, the only way that we can amend the Constitution. And exactly what that looks like is something that I think scholars and the people need to be grappling with, lest we find ourselves in another civil war.
So I'm in principle open to the idea of a third constitution if it was likely that a modern constitutional convention or similar enterprise would in fact result in a better constitution than exists now. I'm not optimistic that would be the case. So before resorting to that, I would suggest we try to opt for better and stronger enforcement of the Constitution that we already have, because many, not all, but many of our problems actually result from departing from that Constitution. So for example, many of the most cruel and unjust policies of the federal government right now and for many years have been in the field of immigration. Under the original Constitution, as James Madison and Thomas Jefferson pointed out, the federal government doesn't even have the power to restrict immigration. If we go back to that, or at least go back closer to it, we won't have ICE agents grabbing people in the middle of the night and acting like jackbooted thugs. We won't have a lot of the cruelty and evil that we have in our society. Similarly, the war on drugs is not authorized by the original Constitution. Remember, they had to have a constitutional amendment in order to allow alcohol prohibition to be federally prohibited. That's because there's no such power to prohibit possession of substances and for the federal government to determine what is allowed to go into your body and what isn't. If we enforce that limit on federal power, we would eliminate many of the other injustices in our society. About half of all federal prisoners are war on drugs prisoners, and about 20%. And at the state level, much of the state war on drugs is also dependent on the federal government. And I can go on with many other examples like this, but part of our problem with creeping authoritarianism in the presidency and unjust and deeply flawed policies is because we've allowed the growth of a wide range of powers that are not permitted under the original meaning of the Constitution. We also have a lot of violations of individual rights that are not permitted under the original meaning. To take just one example, our housing crisis, which is a severe social problem, is in large part a result of exclusionary zoning, which under the original meaning of the Takings Clause of the Bill of Rights, I have an article on this, is not actually permitted, or at least not without compensating people. So there's many examples of this. I don't think the Constitution can solve all our problems, but if we enforced it more rigorously, we could at least greatly diminish a great many of them.
So
The fourth one was extreme political polarization.
Extreme political polarization.
Not that
which
see that.
we definitely have now, yes. Okay, so
Thank you.
I actually really agree with both of you because I think that actually we have a continuing project of changing constitutions. I don't know if we're even on our third or on our many, many multitudes of constitution. And part of the big question of constitutional law is this question of how to connect the moment of the present to a moment in the past of lawmaking, right? And that really is why how we talk about history and how we've had a lot of history today, right, is really important to how we think about the Constitution. So I teach constitutional law, and I have a bunch of people ask me, like, isn't that horrible today? Like, isn't this, like, it's really sad to teach constitutional law today? And I'll say, no, I don't think it's sad. I think it's really hopeful and promising, and that's because if the American constitutional project is anything, it is a project of change. We really have, in many ways, sort of like had the idea of Jefferson that we will have a constitution every new generation. We will interpret something that is very short and very open textured in very different ways. And I think that that means if there are things that you don't like about our current moment, it really is for us, we the people, to build and create a new project, including in response to these 4 bad things that Alan points to, but so that we can have, in our present moment, a constitution that does speak for all of us.
Those words, we the people, as said earlier, were not in the Articles of Confederation, were included in the Constitution. Notably, they were also excluded from the Confederates' Constitution. They went back to the idea of states. So I want to leave the people with some wisdom. What would you, at the end of this discussion, which has been great, so thank you, what would you leave the audience with today?
All right, I'll go ahead and start. Since we were talking about the potential of amendment outside the context of Article 5, what would that look like? And I think that it draws in part on this foundational idea of popular sovereignty, figuring out who we the people are and how we act. Now, we normally think about ourselves as, or we think about the polity as acting through elections, through our representatives. But if we're radically reimagining this, what is the role of states? That's something that a couple of the other panels talked about. And I think that it's at least worth grappling with this deeply unsettled question about whether the states retain any sort of that primordial sovereignty that many of the founders argued that they did in the 18th century. There's an argument that perhaps the founding period itself re-envisioned that, or that maybe the Reconstruction period did. And so I invite creative thought about that.
It's hard to point to just one thing as the one thing that we should remember. Obviously, there's 200 years of constitutional history over which there's been all kinds of debate from the foundings to present. But I will just leave with this one thought, that the American Revolution, later the Constitution, and even more so the Reconstruction Amendments, were born out of suspicion of various kinds of government power and oppression. And at times since then, including in the current moment, we've lost sight of that and have allowed power to grow and to become more concentrated, both in the hands of one man, the president, but also in the hands of the federal government more generally. And when it comes to even state governments, we often have been inadequate in our protection of various kinds of individual rights against their depredations as well. So I think the path forward for us is, the best path at least, is to recapture some of those limits on government power that we've allowed to get away from us, and also, of course, to think in the future about both how we can do what was tried to do during Reconstruction, which is to both expand the amount of liberty that is protected, but also to expand the range of people who get that protection. In that era, obviously, the most obvious goal was to expand the range of people to the freed slaves, but at that time, many also recognized it should be expanded in other ways, including to women. In our time, we have a lot of liberties that are threatened in various ways, but we also need to make sure we expand it to more fully to people who are not citizens, undocumented immigrants, and the like, who are today's analog of blacks victimized by the black codes or the fugitive slave clause.
I really think that the sort of like pressing project of the present is wrapped up in polarization, right? Because the idea of the Constitution is that there is a we the people, and I think there is growing mistrust and concern over whether or not there is a we the people, or whether in fact we're sort of like dividing into different camps, and potentially that we have a government that wants certain people to win and other people to lose. Right? There's retribution, and there's sort of like winners and losers, and that's an appropriate thing. And I think our Constitution, no matter what our differences are on sort of like some of the things we think about, it's that the idea is that it is for everyone, and that we the people requires at a basis that we buy in as a polity to the notion that we want to have a future together, because that's what the Constitution is about. And so I do think that what we need to do is think better about how we can talk to each other across difference, and about the importance of the continuing constitutional project.
I think that's a great place to leave off here. Thank you very much for a great conversation. Thank you, everybody in the audience.